Hello guys, welcome back to our channel Legal Nexus. In today's video, we are going to discuss a very important topic in business law, the Partnership Act. The Partnership Act lays down the rules and principles that govern how partnerships are formed, how they function, and how partners share rights, duties, and liabilities. A partnership is basically a relationship between two or more persons who agree to share the profit of a business carried on by all or any of them acting for all. In this video, we'll look at the meaning of partnership, its essential features, the rights and duties of partnership, and the legal provisions under the Indian Partnership Act 1932. Understanding this will help you in exams, professional course, and also in real life business situation. In this video, we mainly focused on definition of partnership, essential elements of partnership, type of partners, duration of partnership, dissolution of firm, efforts of dissolution, rights and liability of partners, and registration of firm. Our first point is definition of partnership. The law of partnership is contained in the Indian Partnership Act 1932, which came into force on 1st October 1932. Prior to the enactment of this act, it was embodied in Chapter 11 of Indian Contract Act 1872. Partnership is the relation between persons who have agreed to share the profit of a business carried on by all or any of them acting for all. Sir Frederick Pollock defined partnership as the relation which subsists between persons who have agreed to share the profit of a business carried on by all or any of them on behalf of all of them. Partnership is the relation between two or more persons who have agreed to share profit of business carried on by all or any of them acting for all. Partnership and firm. The persons who have entered into partnership with one another are called individually partners and collectively a firm, and the number under which their business is carried on is called the firm name. Essential elements of partnerships. Therefore, the essential elements of relation of partnership may be stated as follows. There must be an association of two or more persons. There must be an agreement. There must be a business. There must be an agreement to share the profit of a business, and must be an element of agency. For example, the business must be carried on by all or any of them acting for all. When we break into these points, we can understand the Partnership Act. There must be an association of two or more persons. A partnership cannot be exist with just one person. At least two or more people must came to start a partnership. For example, if A alone runs a shop, does not a partnership, but if A and B run it together, it can be a partnership. There must be an agreement. Partnership arises from an agreement between the partners, not by laws or statutes. This agreement may be written or oral, and it is called a partnership deed. For example, two friends decide to open a cafe and agreed on sharing cost and profit. This agreement formed the basis of partnership. There must be a business. The purpose of the partnership must be carried on business with the intention of earning profit. A mere charitable activity or social club is not a partnership. For example, practicing law together as partners in firm is a business. There must be an agreement to share the profit on a business. Sharing profit is an essential element. If profit are not shared, it is not a partnership. For example, if A and B open a store and agree to divide profits equally, it is a partnership. There must be an element of agency. Each partners act as both principal and an agent. This means one partner's actions can legally binding the entire partnership. For example, if one partner sign a contract to buy goods for the firm, all partners are bound by it. Partners can be classified into six classes. First is working partner or active partner. Active partner contributes capital and also take active part in management of the firm. He bears an unlimited liability for the firm debts. He is known as to outsiders. He shares profit of the firm. He is a full-fledged partner. Sleeping or dormant partner only contributes capital, does not take active part in the business. He shares in the profit or losses of the firm. His liability is unlimited. He is not known to the outsiders. A sleeping partner can retire from the firm without giving any public notice. Secret partner. Secret partner contributes capital, take active in part in the business. He shares in profits or losses of the firms. His liability is unlimited. His connection with the firm is not known to the outside world. Limited partner. The liability of such a partner is limited to the extent of his share in capital and profit of the firm. He does not take active part in the business. The firm is not dissolved in the event of his death, lunacy, or bankruptcy. Partners in profit only. Partners in profit only shares in the profit of the firm but not in the losses. His liability is unlimited. He is not allowed take active part in the business. Such partner is associated for his money and goodwill. Nominal partners. Nominal partners only lend his name and reputation for the benefit of the firm. He represents himself knowingly, himself to represented as a partner. Such type of partner neither contributes capital nor takes part in the management of business. He does not share in profit or losses of the firm. He becomes liable to outsiders for the debt of the firm. Duration of partnership. The partners may, at the time when they enter into partnership agreement, fix the duration of the partnership or may say nothing about it. In the former case, the partnership is called a partnership for a fixed term, and in next letter case, a partnership at will. Sometimes a partnership is formed for the purpose of carrying out a particular adventure or undertaking. In such a case, it is called a particular partnership, partnership for a fixed term. In this case, partnership can enter into for a fixed period of the time. When the fixed period is over, it comes to an end. The partners may, however, continue to carry on the business after the expiry of the fixed period. In such a case, the mutual rights and duties of the partners remain in the same as they were before the expiry of fixed period and the partnership becomes partnership at will. Dissolution of firm. Dissolution by agreement section 14. A firm may be dissolved with the consent of all parties or in accordance with the contract between the parties. Compulsory dissolution section 41. If all the partners or of all the partners but one as insolvent or by the happen of any event which makes the business unlawful. Dissolution on happening of certain contingency section 42. A firm is dissolved if constituted for a fixed term by the expiry of that term. If constituted to carry out one or more adventures or undertakings by the completion, therefore, by death of a partner and by the adjudication of a partner as an insolvent. Dissolution by notice of partnership at will, section 43. Where the partnership is at will, the firm may be dissolved by any partner giving notice in writing to all other partners of his intention to dissolve the firm. The firm is dissolved as from the date mentioned in the notice as date of dissolution, or if no data is mentioned, as from the date of the communication of then notice. Dissolution by the court, section 44. Court may direct dissolution of a firm on the following grounds. If a partner has become unsound mind, if a partner has become permanently incapable of performing his duty as partner, if a partner is guilty of conduct which is likely to affect prejudicially the carrying on of business regarding being hard to the nature of business, if a partner willfully or presently committed breach of agreement relating to the management of the affairs of the firm or the conduct of its business or otherwise so conduct himself in matter relating to the business that it is not reasonably practicable for the other partners to carry on the business in partnership with him. If a partner has in any way transferred the whole of his interest in the firm to a third party or has allowed his share to be charged or has allowed it to be sold in the recovery of arrears of land revenue or effects of dissolution. A continuing authority of partnership. Authority of partners continuing even after dissolution or so long as it is necessary to wind up the business. Each partner has an equitable lien over the firm assets, which he can apply to pay the debts of firm and to receive any amount due from the partnership firm. Continuing liability of partners. Liability of partners continues till the public notice of dissolution is given. Liability of partners continuing for all things necessary for the winding up of the business. This partnership may complete unfinished transaction. Note: this authority is only for winding up and not for new transactions. Right to return of premium. To buy entry into existing firm, a new partner sometimes has to pay a premium to the existing partners in addition to any investment of capital. On dissolution, he is entitled to demand the return of a proportion of the premium if the partnership was for a fixed term and was dissolved before the expiry of that term. However, in the following three cases, partners will not get the premium in return. Where the partnership was dissolved by the agreement or misconduct of the party seeking return of the premium or death of a partner. Settlement of accounts on dissolution. Losses shall be paid first out of the undistributed profit, next out of capital, and lastly, if necessary, by the partners individually in the profit sharing ratio. The asset of the firm, including the losses contributed by the partner, as above, shall be applied in the following manner: in paying outsider creditors, in repaying advance made by partners, in repaying capital to the partners, and if any amount is left, then it shall be divided in PSR. Section 9 of the Partnership Act defines the duties of partners to carry on the business of the firm to the greatest common advantage, to be just and faithful to each other, and to render the true accounts and full information of all things affecting the firm to any partners or its legal representatives. Every partner shall indemnify the firm for any loss caused to it by his fraud in the conduct of his business firm. Rights of partners. Every partner in a firm has some rights, even their sleeping partner or nominal partner. Every partner has a right to take part in the conduct of business. Every partner has a right of free access to all record books and accounts of the business. The partners are entitled to share equally in profit earned and shall contribute equally to losses sustained by the firm. Where a partner is entitled to interest on the capital subscribed by him, such interest shall be payable only out of profit. A partner shall indemnify the firm for any loss caused to it by his wilful neglect in the conduct of the business of the firm. A partner has power to act in an emergency for protecting the firm from losses. Every partner has a right to retire by giving notice where the partnership is at will. Every partner has the right to continue in partnership or not to be expelled from it. Any difference arising as to ordinary matters connected with the business may be declared by a majority of the partners, and every partner shall have the right to express his opinion before the matter is decided. No change may be made in the nature of business without the consent of all the partners. Registration of firms. The Partnership Act does not provide for the compulsory registration of firms. Registration of firm is optional. Effects on non-registration. Section 69. Suits between partners and firm. A partner of an unregistered firm cannot sue the firm or any partner of the firm to enforce a right arising from a contract or conferred by the Partnership Act. He can do so if the firm is registered and the person suing is or has been shown in the register of firm as a partner in the firm. Suits between firm and third parties. An unregistered firm cannot sue a third party to enforce a right arising from a contract. In order to file a suit by a firm against a third party, the firm should be registered and the name of the person suing should appear as partner in the register of firms. So that was all about the Partnership Act. We understood what partnership means, its essential, and why the Act plays such an important role in regulating business relationship between partners. If you found this video helpful, don't forget to like, share, and subscribe to this channel. Thank you for watching. See you in next video.